Welcome. I'm John Jackson. I'm director of the Center for Entrepreneurship, and it's my pleasure to welcome you to patent trolls and other intellectual property threats, of which there are actually quite a few. This event is casual. I want you to think that we're having a cup of coffee. Yeah, kick off the damn cup. We're going to have a cup of coffee at Starbucks with friends, and we're talking about this issue. And so the rules of engagement would be have your cell phone set on loud. And it's okay to interrupt and ask questions. Again, this is just a conversation, but I don't need the microphone. I wanted to tell you a story, and the good news is, come on in, you're welcome, come on in, I just received a registered letter. And cool, I was thinking maybe I won that Reader's Digest contest. You may have already won, that's exactly my thoughts. And the letter said, please be advised that it was Dear Mr. Jackson, by the way, which I appreciate. Please be advised that our client is the legal owner of U.S. patent number 122526, a copy of which hereto and such patent information is made a part hereof by reference. I didn't know what I was saying at that point. And that it is our belief that your products may be covered by the patent and therefore may potentially be infringing the patent. Our client requests that you cease and desist immediately, and if you fail to do so, our client will escalate this matter using all legal remedies, including a lawsuit. Also, we would really appreciate it if you could provide us your revenues for the past 6 years so we can begin our analysis. Love, whoever it was. And from there, welcome to the world of patent trolls and other IT threats. The Center for Entrepreneurship is engaged with our students here on campus, trying to help them think entrepreneurially and create economic impact. Our students are engaged in consulting projects with local companies, and I bring to your attention that in that blue folder there is an application for our student consulting efforts. There'd be no obligation if you filled it out, and if you turned it in today, we're going to have a complimentary project in the area of leadership or accounting. Our students work with you for the semester. We actually have a couple former clients here in the room, and we would love to help you make your business more profitable. So it's all up to you. If you fill out that application, turn it in at the end, you could actually get a free project, which could be worth on the market a couple $1,000. The event is also sponsored by the gentleman here on my left. We have Conrey Insurance Brokers and Risk Managers as a sponsor, and Foley, Bezek, Behle, and Curtis as a sponsor. The event is partnered with the Family Business Center, some of my colleagues down the hall. So patent trolls are a real phenomenon. They're a threat to startups, small businesses, as well as large businesses. And just a quick definition, and my colleagues will give more on this, but a patent troll is someone who has a patent, who has a business model built around threatening potential infringers in the hopes of collecting money. So their business model is actually the process of making that noise about a potential lawsuit. They target startups and small companies in particular because those companies tend to be undercapitalized, may not have the time, the wherewithal to fight. About 90% of the threats out there for patent infringement by the trolls are to startups and small companies. On the other hand, they also target big companies. In fact, the #1 company that was targeted in 2013 was Apple. And one reason might be Apple has a lot of money, and so you follow the money. Patent trolls are an interesting phenomenon. We're going to explore it tonight, but there's one thing that I have to clarify. There are other types of trolls. So there are copyright trolls, trademark trolls, and in this digitized society where everything leaves a trail, it's really convenient for the trolls. So now I'd like to go forward to the panel, just a couple of quick bios here. On my immediate left is Roger Behle. He's a partner with Foley, Bezek, Behle Curtis, a nationally recognized litigation firm with offices in Orange County and Santa Barbara. Roger heads the firm's intellectual property department. Next over is Jerry Conrey. Jerry is the principal of Conrey Insurance Brokers and Risk Managers, a regional insurance brokerage with an office in Tustin, which was founded in '69. Jerry is an alum of Cal State Fullerton, ladies and gentlemen. And then to my very far left is Dr. Robert Kovacev, who is in faculty in finance and marketing, has an extensive background in technology and international business. What I'd now like to do is turn to the panel and let them open up with a few comments from their particular area of expertise. And Bob Kovacev, I was wondering if you could talk a little about the economics of patent trolls, the business of patent trolls.
Okay, the first time that you're going to run into a patent troll, or potential patent troll, is when you get a letter like JJ mentioned that he's received, a cease and desist letter, and you have to wonder where this came from, and most companies just have no idea whether it's real or not. There are two types of companies that would do this. Number one is a legitimate claim. The company who has invented something, they believe that they're not getting what is due them by another company that has used their patent, or it may be a process, it may be a design, it may be a product that's included in another product. But there's another kind, and that is the extortive kind of a patent troll, and that is a company whose business model is built around extortion, just getting money from companies who can or don't choose to go into litigation, don't choose to do some of these things to protect themselves, and they would rather pay off the patent troll, and that's how the patent troll makes the money. And as JJ mentioned, there are other areas. There was a famous case here in Los Angeles by the Trevor Law Group, and they weren't using patents, they were using the ADA, the Americans with Disabilities Act, as well as the legislation that we have in California for controlling businesses. And they would go in and they would find very small, minor things, like if the restroom door was an inch too narrow for the wheelchair to get in, and they'd threaten lawsuits. And most of these were very small companies, mostly foreign-owned, immigrant-owned. And they would just say, okay, for $5,000 or $10,000, we'll make this go away. And those are the extortive kind. Well, what choices do you have if your business model is threatened by a patent troll? Well, you have a few choices. Well, as a matter of fact, you have several options. Number one, you can pay it off, and this is probably the fastest, but certainly maybe not the smartest. You could go to trial, and you're talking about a lot of money to do a trial to defend yourself against the patent action. You could go back through your entire design to find out, well, is this real? Does our design actually have something in it that it violates this patent that they're talking about? And that's a very expensive process, because you have to do a from a ground up analysis of your design or your processes to see if you are indeed in violation and if you have a defense. So there are a lot of things to do. One is the risk mitigation, and that is maybe you can insure against this possibility. to risk mitigate, and of course that's a very common thing. The government is starting to recognize that this is a very real problem. And as a matter of fact, in the Wall Street Journal, there was an article on last Tuesday the 14th, where New York is cracking down on a company called MPHJ Technology Investments. That is their business model, is to go after people with patent claims, get tributes from them, get payment, and the claim goes away. And New York is cracking down on that. Other states
Can I make a
have done
comment
it
on
too.
that?
Sure.
So MPHJ, how many people today use their smartphone at a public place? Right? He is suing businesses because they allowed Wi-Fi technology to be used in their business. He is asserting that his patent has a protected process or a patent that says that you have to pay royalties to access that technology. So could you imagine being a small barista owner? You know, you've got a little 600 square foot shop, you've got 4 little tables, you got a line out the door of people at 7 in the morning trying to get their espresso to go to work, and suddenly you get in the mail this letter from this company asserting that you have infringed on their patent and that they want $25,000 to go away. Well, 1,000 people, 1,000 companies paid that $25,000 last year. They generated $25 million in litigation or pre-litigation settlements. This is a patent troll, okay? And who it's going to affect the most isn't that small business owner for $25,000. It's everybody that put up their hand just a second ago. Because what these people are going after are things that make life convenient. And where they had these patents, they had them in places where it wasn't for this purpose at all. But they're reinventing its use as a way of asserting their rights. And in some cases, this guy paid $1 for those rights. He paid $1 for that patent right. And last year he generated $25 million in receivables. I'm a little envious. I'm a little envious that he's that clever. But really, that's what this meeting is about today. Sorry, Bob, but I thought it's funny that you mentioned that because I was going to tell that story, so I thought it was pointing to do it now.
Now, the last thing I want to mention is, where did he pay that $1? How did he get a patent for $1? A lot of patents are obtained as a result of a bankruptcy of a company who owns a patent. And if we look at Kodak recently sold 1,100 patents. And the patents are their lifeblood of that kind of a company. They sold 1,100 patents to Apple and Google and Microsoft and others. Well, other bankruptcy proceedings, that is a huge asset that can maybe save the company, and they do sell those patents. That's how these patents get bought by the trolls.
Jerry, why don't we move to you? What are we supposed to do? Is insurance a solution?
If you're the owner of a small business that generates $500,000 or $600,000 in revenue a year, and maybe you bought a franchise to a dry cleaning firm or something like this, insurance is probably not going to be the right solution for you, because these policies are not inexpensive, because the potential for $1 million payouts for defense costs are quite real. The typical, well, I'll let Roger talk about the cost of lawsuits, but the reality is that it easily could cost $1 million to defend your process, whatever that process is that's being alleged. And so, yes, firms that manufacture something, firms that distribute something, firms that import something, firms that export something, firms that use processes or special ways they go about doing something to differentiate themselves from others. All of these types of activities can lead to you being a defendant in an intellectual property litigation. So none of those types of businesses are exempt from exposure. None of them. Insurance, there is insurance products out there that will defend you, that will go to court all the way to defend all the way through the process. If indemnification is appropriate, they'll pay a claim, okay? If somebody is asserting a right that is appropriate and there truly was an infringement. And they also will have the resources to attack the kind of predatory practices that we're talking about in this room, because let's face it, every time one of their customers become subject to one of these, they can spend tens of thousands of dollars defending it. So yes, there are insurance products for it, but not everybody in the room is an insurance policy appropriate for it. And one of the tenets of my business, the way we do business, is, we are not just brokers of insurance, we're also managers of risk. And you mentioned risk mitigation, but I focus on risk management. The difference being that in the process, well, it's really mitigation, management's part of the mitigation process. There's also risk transfer, which is when you sell or buy an insurance policy. But risk management means that you might reduce your exposures by asking yourself the right questions. And so one of the things that I'm going to give everybody today before they leave is a little packet. And inside of it, on the right side, is, in the very beginning, is an area called Enterprise Risk Management. And it asks some really simple questions, things that you as an owner or as a senior manager in a business can ask of your business, so that you can start to evaluate whether or not you have any exposures in this area. And there are tools that you can use. Hopefully Roger will talk about it because he uses them every day, which is to go in and search through the patent offices. All the copyrighted, trademark, and patented processes. You can put in keywords and phrases and do searches to see if you find things that might be infringing, because that's what he has to do in his process when he's litigating or defending. But the bottom line is that as a small business owner myself, I employ 11 people. I know that if somebody came along to me, I'll give you an example. There's a person in Texas right now that is sued 16,000 people last year because the business uses email. I want you to hear me. The business uses email and uses scanning for documentation. And he expects to get $1,000 per employee as a royalty for the use of these processes, because he claims that he owns the rights to those processes. And until somebody gets angry enough to defend, and let me share with you this. You don't want to be too principled in this process, John. It's very expensive. You have to weigh, what's the cost of defense versus the cost of making it go away. But just understand.
I got the answer, 10,000 or $1 million.
Yeah. Well, in fairness, the best way to assault something like this is to go to like a trade association and have that association that has greater resources recognize the threat against all of the folks in that organization, and then have them pool together to defend against, because it could just as easily be any one of the others. That's one of the ways that this can be combated. Legislatively, things are being done right now, but the truth is that none of the things that are being proposed, and it's constantly changing, right, Roger? It's evolving every day. But none of the things proposed will make it all go away, because in the course of making it all go away, you would somehow trounce on the real rights of people who truly have intellectual property that's being abused. And we're not here to diminish that. If we don't protect people's rights to intellectual property, then why should anybody go out and invent anything new? So we have to protect it. But at the same time, when we wrote those laws to protect it, did we anticipate people making a business out of suing people frivolously? No. So we have to figure out a way to counterbalance that. And the Senate right now is wrestling with that as we speak. And so have many state houses. But the truth is that the real defense is either an insurance policy because you have enough revenue that could justify the expense, okay? or a really significant risk management policy that's really evaluated all your processes, and then having a good attorney on staff that can react quickly. Don't fold up, don't ignore it, and don't just pay. Those are the 3 don'ts. If you leave this room tonight, don't do any of those 3 things, because all you're doing is perpetuating the problem. Thank you.
Roger, maybe you can weigh in from an IP attorney's perspective.
Okay, well, the tension here, welcome to my world, by the way. This is what happens day in and day out. Lots of business owners or rights holders find themselves at odds in this arena. And the tension is this. As Jerry indicated, we want to encourage, in fact, right in the Constitution, you can find authority and incentive for people to create things. There's laws to protect artistic works and copyright, inventions that qualify for patent protection, brand names, trademarks. So we want, this is a necessary part of our economy. We want to encourage that. So you have to ask the question, well, how do I know when something is a troll, or someone is a troll, or a business is a troll? When do I get to attach that label? Calling somebody or something or some company a troll? Or is this really a legitimate patent holder who's got a patent? They're all going to be waving around a patent that's issued by the U.S. Patent and Trademark Office.
Or copyright, or...
Sure.
Yeah.
Any of those rights, typically, are going to come from a government office. Once they have those, does that mean they can legitimately do whatever they want with them? There are limits on what they can do. So the first question you have to ask is this trolling activity, or is this really legitimate activity? And that's really what our Congress is wrestling with right now. As Jerry indicated, there's legislation that's already passed the House that's now before the Senate, and one of the issues they're wrestling with is, what do we do with this notion of patent trolls? How do we regulate this? This is a bad thing. Once we attach the label troll to somebody, then we know how to deal with it. But do we want those same rules to apply to everybody? So imagine you've got a young company, they've spent their years and effort and time to develop a patentable process. They obtain a patent, and these are not easy to get. They take years and thousands of dollars, but they've got a patent, and soon after obtaining their patent, they learned that a competitor is now using the very same process, and they're just outraged. I can't believe it. We're hardworking, we built this, and these guys took our patent, and they're now using it to our disadvantage. Now, would we think that that company, in that circumstance, should be able to take steps to protect what it's worked so hard to obtain? And most of us would say yes. How is that different from a company that says, well, I may go acquire a patent, either file one on my own or purchase a patent from somebody, and why should I not be able to enforce that right that's given to me by the government like anybody else? If somebody's doing what my patent says they shouldn't do, why should I not be able to enforce it? So the tension here really is, when do we attach the label troll to somebody with a patent or a copyright? I mean, I'll mention an example having to do with copyrights. Getty Images is a large holder of copyrighted images. Years ago, they sent letters out to many businesses who had images on their websites that were owned by Getty. The copyrights were owned by Getty. Some businesses receiving these notices were quite surprised that the web developers that they hired to create their websites had gone out and pulled copyrighted images that didn't belong to them, and lo and behold, they got a letter from Getty. So it can take place in the patent arena, copyright arena, and even the trademark arena. So we don't have time to really talk about what the differences are between all these different forms of intellectual property, but the first question to ask is this a real troll that I'm dealing with, or is this really a legitimate claim? And how you analyze that question might dictate your view on whether this is something we want to encourage or discourage. Once the troll label's attached, I think we'd all agree we don't want people out there abusing or, as Bob said, extorting people, because it's cheaper to pay these guys off, give them $5 grand, they'll go away, than having to defend. So real quick, and we'll talk about this I'm sure more in detail, but one of the things you can do, and it's going to take a little effort, is before you launch a product or before you launch a business, give your business a name, give your product a name, or launch your website. You can do a little checking. Some of it you can do on your own. Others you can hire a professional to do, but just to make sure you've gone out and done what we in the legal world call clearance. I want to make sure that before I launch my company and my brand, I'm not going to get a cease and desist letter from a trademark holder that says, you can't call your product that because I've already got a registration. A little checking, which frankly doesn't take that long, would have avoided that problem. Patents get a little more complicated because they are complicated creatures and they're defined by the very specific claims that are in each of the patents. But you can do some checking to make sure before you actually launch something that you're actually able to do it without fear of an infringement. Copyright's the same thing. Before I launch my website, I'm going to have some photos on there. Where do these photos come from? How do I know I have the right to put them on my website? They're just very basic things. And again, you don't always have to have a lawyer to start the process. Google's a phenomenal tool that we didn't have just a few years ago, and you can find a lot of information that can be of great value to you that will help you navigate some of these issues. But
It'll also assist you in infringing.
it can.
It can assist you in infringing. If you go and do an image search, if that image is not public domain and you use it without asking permission of the illustrator or the photographer or the person who owns the rights to it, you've infringed. And I can assure you, probably every person in this room at some point in time has infringed on somebody's rights. Usually it's unintentional. And usually it can be quickly corrected if it is brought to your attention. But
By the way, ignorance is not a defense.
it isn't.
You can say, I didn't know, I'm sorry.
Right. Yeah, so what?
That's right. So you just have to be careful, and like I said, there are things you can do if you're a business owner, or even in your individual capacity, to just do some very basic checking before you go forward with something. And I'm surprised in my practice how many people really kind of want to jump ahead and don't spend the time that's required to really do some just very basic checking. And like I said, you don't have to go out and spend thousands of dollars in legal fees. You can do a lot of the checking on your own and make some very basic decisions. So that's the landscape from the legal perspective. We can talk at length about what specific risks you have relative to patents. What kind of business are you in? Is it a method that you might be using? Is it a product you might be making? In the trademark arena, is it what you're calling your product? And it doesn't have to be identical. It can be phonetically the same, and you might get a letter that says, well, it's not spelled the same, but it's pronounced the same. That could still be infringing. You could have a photograph or some text on your website. All of these different things might give rise to a claim, and it may not be trolling. It might be that you just have to guard yourself against even a legitimate claim from a rights holder. So,
I just wrote a note to myself when I get home tonight to go to my Facebook account and delete all those photos.
yes.
But unfortunately, the internet has no eraser, and there's a digital record of everything you do. So we got you. Bob, I wanted to come back to you. You talked about patent trolls and how they might acquire a patent. And you mentioned bankruptcy, right, as one.
Right.
Could you expand on that and what other sources there might be?
Well, bankruptcy is a key one, and of course Kodak is the one that I mentioned earlier. But any small company that is failing will find that they have one asset, and that is their patents. Any patents they may hold that might provide enough cash if they sold the rights to those patents to get them through into a Chapter 11 reorganization. Certainly it's an asset that they can use. I think other ways to get patents are companies, major companies like Boeing that I was associated with for many years. They have huge numbers of patents that they don't use anymore, and they have no intention of using. But right now they're holding on to them, but there's no reason why they can't start selling these patents. One of the things that I was working with Boeing on is to take some of these technologies and patents that, for processes that Boeing was using and spin off companies into other markets that Boeing wasn't interested in, and actually use that intellectual property to disrupt other marketplaces. and some of those would be spin-offs with Boeing employees. Well, there's no reason why Boeing might not sell some of the patents that it's never going to use. So,
Okay, well, when do you earn the title troll? If I go out and I invent something that's patentable, I'm given a patent, is there any reason that I shouldn't be able to sit back in my office and do nothing but monitor other companies? By the way, you know, one of the identifiers of a troll is that they are what are called non-practicing companies, and that basically means they don't have their own business. They may own a patent on how to build the best widget, but they're not making widgets. All they do is sit back and say, who else is making widgets in this way? And if that's, you know, what they choose to do as their business model, the law doesn't prohibit it. You don't have to use a patent. So an inventor could say, I'm going to invent this, and I choose not to make it, use it, sell it, or offer to sell it, which are the rights that the patent holder has to prevent other people from doing, and just sit back and see if anybody else ever does it. And you have to ask the question, how many people here think if I invented something, the US government says I'm entitled to a patent on that, why should I not be able to exercise that patent? Does anybody think that shouldn't be allowed? If that inventor with the patent then decides they don't want to make, use, or sell what they have invented, but they just want to sue other people for it, is anybody that thinks that kind of activity should be prohibited?
I know in other countries, you have to practice the patent or you lose it. Maybe that's one thing that the Senate and government can look at and say, hey, look, I got a patent. If you don't use it or practice it within a certain period of time, it's no longer enforceable.
Yeah, go ahead.
Do most of these people acquire patents and then start litigation early, within 1 to 5 years, or do they start it maybe 5 to 10 years later, or is there a wide variety?
It doesn't matter. And just so you know, one of the common defenses in a patent case, if you ever find yourself in that arena, is the patent isn't infallible. I mean, you can expect if somebody wants to threaten you with a patent, what you're going to see in response is what's called an invalidity claim. You can attack that patent. That's one of the criticisms of you know, these patent trolls, is they have patents that are just ridiculously broad. I think Jared was mentioning, you know, one that says you can't ever use Wi-Fi without infringing my patent. Well, the examiners in the patent office are human beings. You know, they review the claims in the patents. They will typically, you know, go through a process before a patent is issued, and then ultimately they'll, in theory, issue a patent if it's new, useful, and non-obvious. Those are the tests. So if you meet those tests, you get a patent. Now, can I go out and enforce it right away? Sure I can. Do I have to enforce it right away? No. And if I did enforce it, I run the risk of having somebody invalidate it, so I lose it. So what you'll find also with patent trolls is they typically don't have one patent. If I just had one patent, I'm going to hang my hat on one patent, and that's invalidated, as just happened recently before the Supreme Court with a patent troll, they lose their business model. So they'll usually accumulate a portfolio of patents. So on the subject of use it or lose it, then you get into a real difficult you know, dilemma, because the same tension that I described for legitimate rights holders and these illegitimate patent and other IP trolls, are we going to require a startup business to demonstrate to the satisfaction of the government that they've made enough use within 1 year, 6 years, 5 years? Where do you draw that line? And you say to somebody, you know, it took you 5 years to get here, but if you don't show me you're using this thing successfully, marketing it, selling it, I'm pulling the plug on everything you work for. It's a slippery slope. So those concepts, use it or lose it, although they're very common in the trademark world. If you don't use, those are easy. Either you're selling products under this name or you're not. In the patent world, it's typically, you own the patent for your 20 years, and whether you use it or not, it sits on the shelf, or you're actively making stuff. That's really not anything the government's concerned about.
So you get the summons, and you figure out that you can pay it. Should you still settle without legal representation, or should you just go ahead and do it on your own?
All right. So great question, and I'm going to give you a practical answer, and it really is a practical answer. If you're in business, in my view, you need to analyze things from a business perspective. You really do. And I appreciate and I hear all the time, on principle, you know, I want to do this, this, and this. And I really do appreciate that. But there are business reasons to take certain action, and I'll tell you, that's what the trolls will prey on, because they know a prudent business person is going to look at the, you know, disparity. Do I spend $1 million in legal fees, defending this case to trial, and then taking it up on appeal and whatever else this may lead? Or do I spend a couple bucks, get this out of my hair, go to sleep at night, and at least have this off my plate? And that's, you know, that's a difficult decision to make because it depends on the circumstance. But I'll tell you, it's very honorable to say I'm going to stand up and I'm going to fight, and then about 3 months into it, and several $100,000 into it, you suddenly reevaluate that principle that you thought was so important way back when. You have to think long term, because most of these cases don't resolve quickly if they're litigated, and they can go on for months and years, and they get very, very, very expensive. So which is why I said having a risk avoidance or management or even a mitigation plan in place in advance, doing your own homework to the extent you can, and understanding that there's just going to be risks you can never avoid completely, but you can manage those and mitigate them and make yourself less of a target. The more successful you are, unfortunately, it seems like the more that target on your back grows.
Jerry, I got one for you. So as a small business owner, I take comfort in that I've got a commercial general liability insurance policy. Is that going to help me in a situation like this?
Nope.
So much for comfort.
The truth is that you have to understand the tenets of general liability, and when you do, then it makes it really, really easy to understand why it doesn't respond, okay? General liability insurance protects you against bodily injury and property damage, neither of which is being claimed in a IP claim. It's an economic loss. So you have to have special protection anytime you're looking for some kind of a indemnification or a claims payment from an insurer that involves loss of economics or money. What kind of policies do that? Well, if you were a professional, like an engineer, architect, physician, dentist, professional liability provides for economic loss, because the types of things that could be asserted is that through the lack of professionalism or some omission or error, it led to my economic loss as a claimant, okay? And that kind of policy responds to that. An intellectual property policy, there's 4 types. There's policy defense, which is the kind that would resolve all the kinds of things that we talked about today. But is there anybody in the room that actually owns any kind of intellectual property that's here today? Okay, so for those of you that own intellectual property, there's also a policy out there that is called an abatement policy. And it basically defends the economic value of your intellectual property by going after those that are infringing on it. It's an abatement policy. It abates others from using your technology or property without your permission, which in essence is diminishing the value of it, okay? And then there are policies that will respond to, let's see, I covered 2 of them. I just think of all my notes. Those are the 2 most popular ones. The other 2 that are used focus on those that need protection for when you have a, well, it's a multi-peril policy. It's kind of a property protection in the world of intellectual property, where it can be endorsed on as a part of a larger package. This is a much thinner protection. It isn't as significant. Usually it has a very specific limited amount of coverage, but it also is the least expensive type of or form of coverage that a business owner could buy. And then there is the unauthorized disclosure of confidential information. In our world, insurance, we could accidentally disclose something about a customer unintentionally and harm them. There's HIPAA in the health world. There are academic records in the academia, and personnel records all kinds of things and all kinds of, a law firm, you know lots of secrets about businesses because you have to defend them properly. If one of their employees accidentally disclosed something that hurt somebody, this kind of a policy could protect them against that kind of a loss. So those are the kinds of policies that can be purchased by business owners for the different types of exposures that exist out there. Some as defenders, 3 of them as defenders, and 1 as a prosecutor, going after those that are infringing. And that's what's available out there today in the marketplace. But CGL, general liability, no.
Dang, okay. Note to self. Look into insurance options.
Not covered.
Yeah.
Yeah.
Back to you, Roger. What are the laws that regulate trolls today?
Well, we don't have laws that regulate trolls per se, although as I mentioned, there's legislation that's passed the House and is now before the Senate that attempts to address this issue of trolls. And the way they're trying to approach this, and I'll kind of tell you why there's some hesitation in the eagerness of our legislators to move ahead with this, is they're trying to disincentivize trolls from pursuing litigation by making an unsuccessful patent litigant responsible for all of the fees that were incurred. It's a fee shifting. Right now, under the law, the court could award, and the word may appears in the statute, attorney's fees in an exceptional case. And then there's an analysis the court has to do. Was it an objectively reasonable case? Was it brought in bad faith? And the court will do this analysis. Well, the new legislation says, well, that's not deterring the trolls because, you know, if they're unsuccessful, you know, maybe they don't have to pay the fees. They get a judge who says, well, it's not bad faith. You did have a patent after all. So the new legislation says, look, if you sue and lose, you're going to pay the other side's legal fees, and it's a shall. You shall pay. You're the prevailing party, other side that got sued unjustly, and you're going to pay. The reason that's a concern is because, you know, what if a legitimate patent holder files a suit and for some reason it doesn't go well, and now they have to think to themselves, my God, I just sued Apple, who incurred $10 million in legal fees. I can't pay legal fees, but so before I take that step off the cliff and try to enforce my right, I have to factor in now that I'm going to have to pay, it's a must, if I'm wrong and I don't prevail in my case. But I'll never lose. Well, okay. That's what jury trials are all about.
Don't they do that in other countries right now?
Yeah, and the concept of other countries is mentioned. I'll tell you, there's no such thing as an international patent.
No,
per
but I
se.
mean even just a normal lawsuit.
Yeah, other countries have a loser pays, you know, model, and
Most of them do.
right, and it's not just IP. It can be a loser pays in a whole bunch of different
That would be
scenarios.
good if that happened here.
Well, and you're right. So conceptually, you think to yourself, the guy who's not right ought to pay.
Right.
But there's a lot of, and you read about these in the news all the time, there's a lot of cases that just go badly for one reason or another, and it's not necessarily the winner that prevails. It might be the guy that should have lost prevails for a whole bunch of different reasons, and then to add insult to injury, they've got to pay on top of it. If I'm a young company and I've got an IP right that I want to enforce, and I now know the law says if I take my shot, and unless I hit the mark, I'm paying my opponent's legal fees, I'm going to be really, really reluctant to take that step. Because guess what? It's going to be hard enough for me to finance my own litigation, much less if, God forbid, I get a squirrely jury and they come back and they find against me, even though I'm sure that I'm right. Now, guess what? I got to pay the other side's legal fees too. That could be devastating. I'm going to sit on my hands instead. That's the concern about the loser pays model. It's a great idea because you think the bad guys will be disincentivized, but the good guys might too.
The other issue that you have with that, the other thought that you have to think about with that, is that the whole reason why the system is the way that it is today is to discourage bullying. So big corporate isn't going to be able to throw all of its resources and prevent all these people from exercising their rights because they're afraid. And so the legal system in most instances, in 49 of the 50 states, does not have the loser pay mentality. Okay, Texas is the only one that I know of that does, and that's a recent change. But the problem with that is that then you'd have bullies flip-flopping. The whole process would then flip-flop. Right now, you could replace the word troll and put in the word bully, and it would be synonymous. Because what's happening is it's abuse. They're using a intellectual property process to abuse the system. You use the word extortion. It's an appropriate word, but it's really strong. And I get nervous about using that word, but it's how I feel about it, okay? But the reality is bullying is a very fair word because these folks are basically abusing the process in the system. They're abusing it. And what we've got to do is find some happy medium, something that makes it fair, that evens the field, so that you don't have a guy sending 16,000 letters out to people who have the same SIC code, just assuming that they are doing something inappropriate, never walking foot in their business, never knowing whether or not they actually do, and putting the burden on the receiver of the letter to defend and prove that they aren't doing something versus it being the other way, which is what the system is supposed to be, okay? So that's what I think we need to see the legislature do. I don't know whether that process would solve it or not, Roger, but it's certainly worth thinking about. I like what I'm hearing.
I was going to input that extortion may be a strong word, but what's interesting in most cases, this behavior is legal. It may not be ethical, right? There are some trolls that are, in effect, crooks. But what they're doing is they're using our basic laws and our patent rules and applying it to make money. Correct? That's right. Do we have other questions out there? I saw Bernie. Go ahead.
What if you simply ignore the troll or send a letter back and say, contact me in a couple of months, I'm in the process of moving my business to China?
Well, I will tell you from experience that sometimes that tactic, what I'll refer to as, I'm just going to tell you to pound sand and see if you actually make good on it, will work. Sometimes. You should not ignore any of these. Everything you receive in this context you should take very seriously. But sometimes you say, look, and you can write it in a variety of different ways, but you can say, pound sand, bring it on, I'm here, and I'm going to fight you as long as I need to fight you. And sometimes they look at that and they go, you're not low-hanging fruit, I'm on to the next guy who is low-hanging fruit. And it happens.
You know, my sister is a clinical psych, and she says in working with a bully, you have to respond with similar gusto. They're unaccustomed to people pushing back, and generally they'll take a step backwards and might go away.
Yes, sometimes that's the right approach. And if they're insistent on, you know, you'll find out soon enough in response to your letter, you'll get a suit or you'll get another letter, which is going to put you back right where you were. One of the things I will mention though, you know, when you get a letter that says cease and desist and you decide to ignore it, and let's say the claim was a legitimate claim, you can run into problems with willfully then, after you have knowledge of the patent, and here's this, and you should stop, and you just say, I'm not even going to look at it, I'm just going to keep rolling on, that could worsen your problem. So don't ever, that's why I said don't ever ignore those things. Go ahead.
Are there any, for each idea for how to stop this, there seems to be a pitfall. It's going to limit people from actually defending their patents. Is there any ideas out there right now that would seem fair to balance it for both ends?
Well,
that are maybe unpopular politically, that would actually do good to limit this whole situation?
There's a lot of discussion, and I will tell you that all of the solutions as are styled are economic based, because that's really what drives the trolling activity, is I can make a living, my dollar investment buying a patent that's about to expire, or maybe assembling a portfolio of patents out of bankruptcy, and I can just start sending these letters out and make money on it. economics seems to be the key. The question is, how do you identify what we consider to be trolling activity and hit them where it hurts, which is the water? And the solution that seems to be the one that has the most traction is really impose a very high threshold of negative consequence to these trolling companies if they try and they lose, and they won't do it again. I mean, you start weeding them out, and then in theory, others won't take the same shot because they figure, I can just get out of this. That's a strategy that patent trolls will use. Even if they get into litigation, they might decide at the courthouse steps, right before you're about to go start your trial, I'm going to lose. And one of the tactics they have is they give you what's called a covenant not to sue. I promise I'm going to drop this. Well, in federal court, you just can't decide to do that as you're walking in for your trial. And so the tactic they used to use anyway was, I'm just going to give you this letter and the court won't have jurisdiction over me and I'll just go on to the next guy. The new legislation says you can't use that tactic anymore. You can't just wait till the 11th hour when you're about to have your day of reckoning and you just decide to pull the plug and without any consequence. They're trying to make sure that once you start the process, if you're sure you're going to win, Mr. Troll, and you don't win, it's going to be real bad news for you if you're wrong. So the answer is, it's economics. It's finding the right combination of disincentives for the bad guys that's not going to harm the people that have legitimate grounds for pursuing claims.
Is there a board or anything that oversees the selling of patents, meaning from one company or individual to another that can either approve it or deny it?
No, the only time this might come up, I mean, the U.S. Patent and Trademark Office issues the patents, and then they have a repository, as it were, for patents that are assigned. So a sale of a patent is usually done by way of an assignment. So I own the patent, it's a piece of property, and I transfer it to XYZ company. And I might record that with the U.S. Patent and Trademark Office. But the U.S. Patent and Trademark Office isn't looking at that saying, well, are we going to allow this? Is this sale being made to somebody we don't approve of? And, how would we even evaluate if it's somebody we don't approve of? The trolls also use shell companies. They'll set one up, and call it the Most Honorable Company, Inc., and then they'll put a bunch of patents in it and assume that because it's a brand new company, there'll be no history and nobody will red flag them as a troll. And then when that gets shut down, they'll start the Most Honorable Company 2,
Right.
Inc., and then move patents into that. So
Which is legal.
all of this fancy footwork is the trolls navigating the system we've set up. So the answer is, unless it's something like an antitrust, where the SEC's involved, that, do we want these companies to merge and there's a patents being part of the merger, nobody's looking at to see, can I sell this patent?
What your intent is.
Yeah, they're not going to look at that.
Are most of these companies, or these trolling organizations or companies, are they small or are they large? Less than 5 people, less than 10 people?
Well, I mean, it's hard to say because they don't really do anything other than sue people. So
Threaten to sue people.
well, some of them make good on the threat. But oftentimes I've seen in other contexts, copyright trolls, for example, will have what I envision to be, because I've only heard them on the phone, these boiler rooms with people that are just on the phone all day long, following up on a letter that they sent that says, we've got a lawsuit pending in district court in the Central District of California. You've not been yet added to that lawsuit, but unless you pay us $5 grand, you're going to be added to this. You want to check it out? It's already on file. You can go look it up.
That's real.
And it is real.
Yeah.
So the answer to your question is the revenue per employee from a business perspective, it's excellent.
Well, I'm trying to think if it's a limiter that could be used, like, you have 100 patents but only 2 employees, you can't go around. So then again, it could be a small business.
That's the hard part.
Legitimate
If it's a
business.
legitimate business that just decides to run lean and mean, are we going to, lump them in with these bad people we're calling trolls?
I think the key thing is there are no simple answers to this. If there was a simple answer, it already had been found. And it would make this an interesting subject matter for all of us to spend an hour today talking and listening about it. It isn't simple. It's being studied and evaluated, and it's growing and evolving, and certainly things are changing. They will change. The practice right now as it exists today will look different 2 years from now. There's no question, because they're on everybody's radar right now. and it's evolving. But as a business owner, and I'm speaking to you mostly, senior managers in companies and business owners, people who have true property to protect, who have jobs to protect, you've got to come away with this meeting today asking the right questions. I'm not up here saying I have all the answers, but I can tell you right now, I can ask the right questions, and through those questions, we can learn whether or not you are well prepared for this kind of potential threat. And that's what this was about today, was to arm you with ways that you could go back and protect your business. And that was why the university put the seminar on.
Yeah, thank you. Tom, you had a question?
Yeah, I just want to, is Congress considering criminal penalties at all? Like if you show bad faith, I think about anti-cyber squatting laws and all that kind of stuff. I think to really hit home is that, okay, you show bad faith or something like that, maybe you go after these guys and notice for criminal penalties.
Yeah, the current legislation doesn't have a criminal component in the sense that you'd be prosecuted, convicted, and thrown in the slammer. The approach is an economic one where the fines might be tantamount to your life's now ended, at least economically. There's a concept in the law called punitive damages. The patent statute really doesn't speak to that. There's something where the judge can enhance the damages if they think it's really bad conduct. But that's another way, is to make the economic penalties so horrible. There's somebody that just takes a shot and is exposed to have a bad patent or an illegitimate intent or motive, that they're not going to do it again. It's not an attractive business model. You lose one of those, and here's the other thing: if the public knows, if legislation is passed where the public says, I now know that, at least on the books, if somebody's taking a swing at me and they're wrong and they're one of these trolling outfits, I now know from what I know of the new law that they're going to really suffer. So maybe I'm going to be more inclined to say pound sand, because I now know there are changes in the law that might, make it more difficult for you to make that choice to actually do something about this. Right now, it's not enough of a disincentive, the way the law is currently situated, for these people not to do what they do. So we have to make it, so that they're not going to do what they're doing.
So we have time for one more question, please.
Hey guys, my name's Steven. I think there's one topic that we've kind of touched on but danced around a little bit, and I'm sorry, I'm bad with names. Your name?
I'm Jerry.
Jerry. Okay, I know you brought up don't fold up. Now let's say that I am a small tech company in California, in Escalade. My expenses currently exceed my revenue. I have no seed funding and no angel investors, so I'm going it alone. I get one of these letters in the mail. It sounds like it's good business decision to fold up and just reincorporate and just dodge it all together, because whatever I have, if I'm not making enough money, may not be significant enough yet. And if you're creative enough, what do you need? A name, a business logo, file your own corporation with Secretary of State, and just restart and dodge it all together. Does that not sound like a better plan at the moment?
Well, I'll respond, because you actually took my comment out of context. My comment was, don't be a victim, okay? And what I mean by that is don't just write checks to make it go away without really weighing all the things that happen. Because every time you write that check, you've invented 100 more people that are going to get the experience you just had. Every time you pay, 100 more victims will happen, okay? It's about the number. And so that's what I meant by that. But in response to your question, can you shuttering up solve your problem? It might, but just shuttering up doesn't protect you. It doesn't mean that what you did that they claim infringed. But if you are, if you can't bleed blood from a turnip, I think that's the term that's used. If there's nothing there, you're not much of somebody they're chasing anyways. They're going after viable business that does have cash flow, but doesn't have the resources to completely defend a suit. That's who they're looking for. So you, in your scenario that you just defined right now, you're probably too small.
Okay.
But a business that's doing $3 or $5 million in sales a year, employs 25 people, they've got the ability to write a $10,000 check. And that's who they're going after. And do you know how easy it is to have to go online and get a list of people that fit that description? It takes about 15 minutes. And that's the problem, is that if they go and they look at businesses that have certain SIC codes and certain business size, a certain number of employees that have been in business so long, they now have their target. And half the time the letter, like even the way that it was mentioned, the way you read it, was perfect. I believe that you are infringing on my rights. They don't even assert what it is that you're doing specifically that infringes. They now want you to feed them enough data that they can find a way. That's why you need legal help sometimes.
By the way, the new legislation, one of the factors is they have to now specify. They can't just send this vague letter that says we believe this or that. You've got to actually lay it out in rhyme and verse. So put your money where your mouth is and explain to me in a letter or in your lawsuit if you file one exactly what I'm doing wrong and exactly why you think it violates your patent. You don't do that in rules.
Don't they also have to list the company name as well, no more endless shell companies?
Yeah. There's a disclosure, transparency is what it's referred to in the, anybody wants to look this up, it's House of Rep, what is it, 3309. If you want to go look it up and read the text, it's not that long, but they want transparency, they want to know exactly who it is that is holding the patent, is it a shell, who's the real owners, and now you got to tell me exactly what I'm doing wrong. Tell me rhyme and verse.
See, Bob, did you
I'd
have a
like
final
to
comment?
address the strategy behind that, which you just mentioned. Sub-S, you're almost judgment-proof, legally you're protected, but what about your customers or potential customers that have identified you as somebody that they might in the future buy from, and you dissolve and then you reform? I think that would probably hurt you a lot. Your credibility as a company in the future, I think, would be destroyed. Why would I want to buy from somebody who just folded and then he came back in business? It's almost like a fly-by-night.
Jerry,
So
did you have
to
comments?
worry about that sort of thing
Yeah.
too.
No, I just wanted to just say that some of us can stick around after to answer particular specific questions. Maybe somebody in here has a burning question that it's really kind of private. They don't want to share it in front of everybody. We'll be here to answer some of those questions. I have a little informational packet for those that would just like to come away with some risk management techniques that they can take back and the questions that they can start asking themselves to see whether or not their business is exposed and they need to be thinking about it. And we just want to thank, what a nice group.
I'm a
John?
happy guy. This was a good deal. Thank
Yeah,
you.
it's great. Thank you very much.
I'd like to thank Bob Kovacev, Jerry Conrey, and Roger Behle for being our panel. Thank you very much. And there's always people behind the scenes who make this happen. Adrian Bailey, Travis, Lindsay, Charles Settlement.